So, generative AI, it's not just some lab experiment anymore, right? It's out in the real world. It's drafting our emails, it's creating art, and now it's making its way into one of the highest stakes professions out there, the law. But with all that power comes some serious risk, and believe me, the legal world is scrambling to write the rulebook for this brand new tech. Okay, let's get into it. I mean, this is the big question, isn't it? We're already seeing lawyers use AI to help with briefs and research, but wow, has it opened up a huge ethical minefield? What happens when the technology just gets it wrong? Who's on the hook?
And yep, this is exactly where things have gone spectacularly wrong. That critical duty to review, it's been ignored. We've all seen the headlines about lawyers getting sanctioned because they cited totally fake, hallucinated court cases that an AI just made up. It's a massive problem, and it cuts right to the heart of our trust in the legal system.
Look, this isn't some what-if scenario for the future. This is happening right now. And with the stakes being this high, the whole Wild West phase of AI in the legal field, well, it's coming to a close. The profession's top ethics authority is finally stepping in to lay down the law.
That's right. The American Bar Association, the ABA, the definitive voice on legal ethics in the U.S., has just put out its very first formal opinion on how lawyers are supposed to handle generative AI.
And this is it. Formal Opinion 512. You can think of it as the new official playbook. It's all about giving lawyers clear, ethical guardrails so they can use these incredible new tools without failing their duties to clients or to the courts. So, what's inside?
All right, first up, the duty of competence. The ABA makes one thing perfectly clear. You can't just push a button and blindly trust what the machine spits out. A lawyer has an absolute responsibility to understand what their AI tool can do, and maybe more importantly, what it can't do. So, just how big is this risk, really? Well, the ABA opinion points to a pretty startling Stanford study. It found that the top legal AI tools hallucinate, which is a fancy way of saying they just make stuff up, somewhere between 17 and 33% of the time. Just let that sink in. An error rate of up to 1 in 3 when someone's freedom or their entire savings could be on the line. And there's a really simple reason why these mistakes happen. A lawyer's job is to use professional judgment, to understand nuance and context. But a generative AI, its job is just to predict the next most likely word in a sentence. It doesn't understand the law, it's just really good at mimicking the patterns in the text it was trained on. So at the end of the day, guess what? The buck stops with the human. The ABA is crystal clear on this. A lawyer can use AI as a tool, for a first draft or to brainstorm, but they can never, ever delegate their professional judgment to a machine. The lawyer is always responsible for the final product. Okay, so that naturally leads us to the next huge issue, confidentiality. This is the absolute bedrock of the whole attorney-client relationship, and tossing a third-party AI into that mix, that creates some serious new dangers. I mean, think about it from your perspective as a client. It's a pretty terrifying question, right? You share your most sensitive personal or financial details with your lawyer, assuming it's all in confidence. What if they just paste all of that into a public AI tool to draft a document? Where does your data go? While the ABA opinion calls out these dangers loud and clear, that sensitive data you shared, it could very well be used to train the AI model. Even worse, bits and pieces of it could show up in an answer for a totally different user. And that user could even be the other side in your legal case. The risk of your secrets getting out is just massive. Because those risks are so high, the ABA says if a lawyer wants to put any client info into an AI tool, they have to get the client's informed consent. And we're not talking about some tiny print you just check off. This means the lawyer has to clearly explain the specific risks, what info they're using, how it could be used against you, and what the benefits are. It's a really high bar to clear. Okay, next up, we're bundling two huge duties together under one big idea, integrity. This covers a lawyer's duty to be honest with the court and their duty to be fair when they bill you, the client. It really is all about honesty. Candor toward the tribunal. It's a bit of legal jargon, but it just means you have to be truthful with the judge. This isn't optional, it's an absolute non-negotiable duty.
A lawyer simply cannot knowingly lie about the facts or the law in court. And this is where those AI hallucinations go from being just an embarrassing mistake to an absolute ethical catastrophe. Handing in a legal brief with fake cases isn't just a slip-up. It's a direct violation of that duty of candor. Relying on a flawed AI analysis can lead to making false arguments, and that can get a lawyer into some very serious trouble.
But hey, honesty isn't just for the courtroom, right? It goes all the way to the client's invoice. And the rise of AI is creating a whole new set of questions about what a fair and reasonable fee actually is. Just take a look at this. It's kind of a tale of two bills. Before AI, a lawyer might spend, say, 10 hours researching and writing a complex legal motion, and they'd bill the client for all 10 of those hours. But now, with a powerful AI tool, that exact same task might only take 1 hour of prompting and careful review.
So here it is, the million-dollar question. And the ABA's answer is a very clear no. If a lawyer is billing you by the hour, they have to bill for the time they actually spent. They can't charge you for 10 hours of work if it only took them 1. The fee has to be reasonable for the work performed, and that means the efficiency gained from AI has to be passed along to you.
Okay, so we've talked competence, confidentiality, honesty. After all these new rules, what's the big takeaway from all of this? Well, it all boils down to one simple but really powerful principle. And that core message is a reminder of who is and always will be in charge.
And there it is. It doesn't matter what tool they use. It doesn't matter what the technology is. The lawyer, the actual human being, is always 100% responsible and accountable for the legal work they do. You can't blame the algorithm, period.
So in the end, the ABA doesn't see AI as a replacement for lawyers. They see it as a potentially revolutionary tool. You know, just like a law library or a word processor, it can make a lawyer's work better, but it can never, ever replace their ethical duties, their expertise, or their basic professional judgment.
So for lawyers, the answer is crystal clear now. They're responsible. But as AI keeps moving into every other profession, medicine, engineering, journalism, this is a question we're all going to have to answer. Who's ultimately in charge? The human or the tool?